All right, welcome everyone. My name is Rilus Law. Got another exciting show today. So we're going to be talking about some advanced estate planning topics. Talking about a new option in Arizona to have a digital driver's license. Pretty cool. So thanks everyone for tuning in. If you have any comments, any questions, any topics you'd like me to cover, you can leave those in the comments. And thanks everyone for tuning in. So let me go ahead and share my screen here. Now, before we get started, I want to point out, if you haven't done an estate plan, I got a free option for you. So if you haven't done a will, you can get it done for free. So you can go to our website, danalegalhelp.com, click this button right here, and I got a free last will and testament template for you and the instructions. So it makes it super easy. So no excuses. Get your estate plan done today, or at least, get it done today. Get a will done today. You can always improve it later. This is really important for unmarried couples, or if there's people that you consider family, that you consider children that aren't legally adopted. So, all right, first topic I want to cover is this new option in Arizona to have a digital driver's license. What do you guys think about this? I think it's kind of cool. It's interesting, just things shifting digital. It's happening. So this is the news from NBC. And then I saw this on ADOT, Arizona Department of Transportation, azot.gov. They have this information. It looks like there's an app that you download, and then you can download the app, register your phone number, scan your ID, take a selfie. So, legal requirement to take a selfie, kind of funny. And then that's how you set up a mobile ID. Let me know what you guys think about that. Do you like the mobile ID? Is it a good thing? Is it a bad thing? The convenience is nice, but how much information are they going to be taking? Other information as well kind of opens the door for that, where you don't know all the information that people could be scanning, but I guess these apps are supposed to keep it secure. So interesting stuff there. All right, let's get into our other topics for today. We're going to be talking about some advanced estate planning topics. So this is where I practice law, Dana and Associates, Arizona, California. You can reach out to us. danalegalhelp.com is the website. Easiest way to find us. Okay, so this is one of the best trusts, the best advanced estate planning trusts for married couples. Now, there's two major reasons why you would need this mandatory AC trust. So one reason is tax planning, to get some other tax benefits. Another reason, or a different reason, could be to exercise more control over your assets after you pass away. So let's see how this works. I'm going to go through this a little bit faster today. I've done other videos in the past about this mandatory AC trust, so you can go in and watch those if you want a little bit more information. So the advanced trust, it always pours into a dynasty trust. Revocable, as long as the trust creators are alive, they'll transfer their assets in there. And here's how it looks after one person passes away. So the alive spouse takes all of their assets, or their half of the community property, into a trust that is revocable. They still have full control over their half of the assets. Now, the deceased person's assets. All right, so the alive person, they're going to be the beneficiary. They're also going to be the trustee. They're going to be in charge of managing this. And all of these assets are going to get a step up in basis to the fair market value as of the date of death. All right, and then after the surviving spouse passes away, whatever, their share of the assets, their half, is subject to the estate tax, but they have their exemption against the estate tax. Currently, that exemption's 10 million adjusted for inflation, a little star. So it's actually 11.7 million in 2021 for those that want to get technical. And then these assets over here will get another step up in basis when the surviving spouse passes away. Now, a lot of the trusts that I do, a majority of the trusts are what we call a continuation trust, where it just has this portion where we send everything to the surviving spouse. So they have full control over everything, and then everything gets another step up in basis when they pass away. And then there's one exemption to use against the estate tax. Okay, so with this advanced trust, this is a little history in estate planning. It used to be very common to do an A-B trust. Now, the main idea of this trust was to get a second exemption against the death tax. So this is how we got to use the exemption of the deceased person. A whole other trust had to be created. So this B trust is irrevocable. The dead person's share is irrevocable. So whatever their wishes are, it can be locked in. So besides the tax reasons to do this trust, the other reasons is if you want to have more control over what happens to your assets if you're the first one to pass away. As part of this control, it depends on who you name as the beneficiary. So to really get control, if we're doing this reason, or if we're doing this trust for the non-tax reasons of you don't want your kids to be disinherited by the surviving spouse, or you don't want to support your spouse's new partner, then the trustee really matters. You really need an independent trustee to oversee the trust. If you name the surviving spouse as a trustee, there really is no protection. So if someone wants to set up one of these trusts for the non-tax reasons, I do require them to get other trustee. Otherwise, it just doesn't work. I've been on all sides of these things. I've represented all different parties. So it's really easy for a surviving spouse to change this trust. I've done that for a lot of surviving spouses. Okay, so the tax reasons over here. Okay, the beneficiary of this trust is always going to be the surviving spouse. They get a benefit during their lifetime, but you can choose who the remainder beneficiaries are. Now, with this traditional B trust, the assets, they use the exemption on the way in. So all the growth, whatever it grows to, is not subject to the estate tax. But there is carryover basis. So meaning, if the house was worth $100,000 when it went into the trust, but on the second death, if the house is worth $150,000, the basis remains the first $100,000. So there is no step up in basis. If the kids sold the house for $150,000, they may have a gain to pay for the difference between, or there may be taxes paid on that gain, the difference between the basis and the sell price. All right, so old traditional estate planning, we did A-B trust, and then the overflow went into a C trust, also called a Q-tip trust. Not to clean your ears, it's a qualified terminal interest property for those that want to get technical. But basically the C trust was an overflow for the B trust. So if it was a $25 million estate, 12.5 would go over here to the surviving spouse, 12.5 over here to the B trust, and then the amount over that exemption would go into the C trust. So the C trust is also irrevocable. And the beneficiary of this is going to be the surviving spouse. It has to be, and the surviving spouse has to be able to get all of the income from this trust in order to use this marital deduction. The trustee, again, you can, if you want to control, you can have an independent trustee, or if we just want the tax reasons, the surviving spouse can be the trustee. Now, the assets that come out of the C trust on the second death, they are subject to the estate tax. But they get a step up in basis. So this new concept came around a few years ago. I guess it's been about 5 or 6 years now, but called portability. And what that means, it means that the surviving spouse can take the exemption of the deceased spouse without a trust. So it means that this B trust is no longer necessary in order to get the second estate tax exemption. So when that became a permanent option, the planners, all the tax nerds got together and they said, wait a minute, what's the best way for people now? How can people minimize taxes given these new laws and these new options? So for a lot of people, it's better that their assets or half goes into the C trust because the assets get another step up in basis on the second death. Now with portability, they can use, it's taxable, it's subject to the estate tax, but there's a second exemption that can be used on the second death. So you can get 2 estate tax exemptions. Now this video, we're going to get into Dynasty Trust, talk about the GST exemption. So portability, you can allocate your exemption against the estate tax, but it is not for GST exemption. So GST exemption, basically there's a limit on how much you can put into these dynasty trusts, these GST trusts, because these dynasty trusts are not subject to the estate tax again. So whatever amount goes in here is not subject to the estate tax again. So all of our trusts contain, all of our dynasty trusts contain what I call a GST filter clause. And what that is, it's a clause that basically says don't overflow this dynasty trust. Don't put in more than the GST exemption. So if the trust has more than the GST exemption, then the excess goes somewhere else. All right, good stuff. GST exemption is different than the estate tax exemption, although they're currently both the same amount. As long as I've been doing this, they've always been the exact same number, but I think they could be different numbers, and maybe in the past they were, but just never during my day. Now this B and C trust, they can also allocate GST exemption. So it is possible to get the second exemption against the estate tax through portability without a tax return, but to allocate, to get the second GST exemption, so where you can put more than 10 million, so up to 20 million into these dynasty trusts, we need a way to get that second exemption. So that's some of the tax reasons why you would need this more advanced trust to get the second GST exemption. Okay, so I was busy making these slides all the way up to the start time. I actually started about a minute late. So usually when we create a dynasty trust, so everything goes into that filter clause, make sure we don't overflow it. Most commonly, the distribution of the dynasty trust is to create an individual dynasty trust for the trustor's then living issue by representation, meaning all of the kids would get their inheritance inside of their own dynasty trust. And if one child passed away before the trustors, then their children would get their share in a dynasty trust. All right. Another way we can do it, it's common. I have clients where they want to give some things to their grandkids. They want to send some things or part of their estate to their children and part directly to grandchildren. So we could set it up where a percentage goes to your children in Dynasty Trust and a percentage to your grandchildren in the Dynasty Trust. Now you'll notice this language here says 50% to trustor's living children. So this living is a condition, meaning that the children have to be alive at that time. And same thing for the grandchildren. So 50% to the trustor's living grandchildren. Now, by adding this condition in there, saying the grandchildren have to be living, that defines the class, and it also closes it, because as long as the trustor's children are alive, they could always have grandchildren. The law calls it the fertile octogenarian rule, meaning someone can always have children. And even though that might not physically be possible, you can always adopt someone. So if we say 50% to the trustor's living grandchildren, then however many grandchildren are living at that time would get a share. They would get a trust. They would get a dynasty trust, and we could divide it between all of the living grandchildren. All right, where things get more challenging. So recently I met with a client this week who he was wanting to set up something for his grandchildren. Let's go through this first. So if we have dynasty trusts that go for the children and the grandchildren, the living grandchildren, so they're all defined. This case, there's one living grandchild and then two children. So under this scenario, 50% to the grandchildren, 50% to the children. So this grandchild would get 50% in her dynasty trust, and then 50% would be divided between these two children and their dynasty trust. So 25% each. And then the dynasty trust, usually I let the trustee, or I let the child or the beneficiary become the trustee at age 35. So these kids are over that. So they could be the trustee immediately of their dynasty trust, but we would need someone else to manage things for this grandchild until she reaches the age of 35. Okay, here's another option. So this one says 75% to a dynasty trust and 25% to what I'm calling a legacy trust. The dynasty trust is what we just saw. And here's what I'm calling a legacy trust. So this is a common request that I get. I had it again this week. But they wanted to set aside a sum of money to be used by grandchildren that aren't even born yet. So this client, his children were all minors, so there's no grandchildren in the picture yet. But he wanted to create a plan where there's money set aside that could be used for grandchildren. So the first thing we have to do is decide who's going to manage this trust. Who's the trustee going to be? That's easy enough. We can choose someone for that. But we got to make it really clear for this trustee. So we're going to have to define the beneficiaries. So who are the beneficiaries of the trust? So one way is possible where there could be a sum of money sitting here to be available for once grandchildren are born. If we do it that way, when does the class close and how much is each beneficiary going to get? So we're going to define the beneficiaries. Let's say this trust was funded with $1 million. Who are the beneficiaries and when does the class close? And what can the beneficiaries receive? So these are some of the challenges with designing a legacy trust. Do we want to keep it what I call a common pot trust where all the money is sitting in one place? Or do you want it to be to go into individual trust once the grandchildren are born? And then what can the trust be used for? Sometimes I've done these where it's education only, where they'll set aside a sum of money that can be used only for education. And then we close the class once the youngest, usually we do it based upon the age of the trustor's children. So we say once their children reach a certain age, or if all the grandchildren are born, and I think it's unlikely that more grandchildren would be born, we can say the class closes once the youngest grandchild reaches a certain age. So if there's money in here that's to be used for education only, what happens if everyone goes to college, everyone's done with school, and there's still money in here? When is this trust going to end? What can they receive? HEMS, health, education, maintenance, and support. This is what the IRS calls an ascertainable standard. And this is the common standard in most trusts of what beneficiaries can receive things for. But again, support and maintenance, that can be pretty broad. So what if a beneficiary wants to buy a house, or what if they want to start a business? Is the trust going to provide for those things? And if so, we got to make it really clear for the trustee in how they can use these funds. I typically, it's not that I don't like these legacy style trusts, they're just a lot more complicated. So that means extra fees, it means a lot more time and money to set this up. It also means a lot more time and money to administer these trusts. So usually it's my preference, when people want to divide between the kids and grandkids, I like doing something like this, where we'll send everything inside of a dynasty trust that has the same terms for the children and grandchildren. It's just that the grandchildren, the younger beneficiaries, won't become the trustee until they reach a certain age. But the children and older beneficiaries, they can gain control of their share sooner. So this is a much easier way to go. It's easier to set up and it's easier to administer. So. All right, so that's it for today. Thanks everyone for tuning in. If you don't have a will, go do one. I think you can do it in less than 15 minutes. You should time yourself how long it takes you to do a will. Good thing to get out of the way. I was just helping people this morning. We were just back here signing their estate plan. And they were relieved walking out of here. They're like, oh, it feels good. Glad to finally have that in place. It's a holiday weekend this weekend coming up, so they were headed out of town, and they were relieved to have their plan done. So get your plan done today. Start for free, or if you want to come see me and get more advanced, give us a call. You can visit our website, danalegalhelp.com, or the phone number is 480-924-4424. See you next week.